who are seeing this stuff day in and day out. And it goes to the question, how many other potential Sandusky situations are out there? We don't know with any precision, but we do know indirectly that it's a great big problem.
Well, Bill, you know, that goes back to me having that mantra of prevention, prevention, prevention. And it's educating the public, like you say, people next door saying, my gut tells me something's wrong. You know, I know that kid's acting out. Like, I had this conversation with my grandkids in junior high. My grandson was talking about everybody laughing at this girl because she's cutting herself. Well, I had to explain to him there's a reason that child's cutting herself. But where was the system, you know, that she's sitting in class and everybody else knows it, and I'm wondering where's the system that doesn't recognize the fact that if a teenager's cutting herself, there's a problem. So I think that goes to we have got to educate the general population about our responsibility to trust our gut when we see that kid and something's going on. So that also means maybe there's some other sort of system, because the reason people don't report, they don't trust the system, they don't trust their gut, and they don't know what's going to happen, you know, once they report. So I think that's where there has to be some sort of way, there has to be some way to catch those and make people in our communities feel comfortable with talking to, you know, getting that information out, whether it's through the, you know, physicians that feel comfortable in doing it, school teachers that, even the neighbors. So where's that catch system for those other 90% of the kids that somebody knows about? Somebody knows about that other 90%, but they're not talking for lots of reasons. Shame is one of them. We see how victims are treated when they do come forward. So that's the bigger piece to get to the 90%, is that whole secondary prevention piece. Once you start to suspect it, we have to start feeling comfortable with going somewhere with that information.
And if you, in fact, could, you know, you have the Childline system, you know, which is run by the state, and then the GPS system, which is county. And if a call comes to the Childline, if it gets, you know, and there may be calls that aren't getting picked up, as you said, but if they don't meet the criteria, how does it get back to the county to deal with that? You know, and so, because the county gets a call, and it's a CPS call, we would say call the Childline, and hopefully somebody does that, you know, but it's that back and forth, having this bifurcated system, you know, is a problem, you know, in terms of how do you bring that together so you have a uniform way of...
This is your chance, because that's one of the issues we've
No,
been
I'm
bouncing
following
back
up
and
with
forth.
what you said.
Is Childline the gateway? Should it be the gateway?
If it's
Or should it be-
adequately staffed up and if it's responsive and you have state-of-the-art to make that happen, but given the resources that the state puts into it, you know, that's a real, as Bill talked about, resources, that's critical. You have to have the ability to take those calls and to deal with them and to get it to the county to do the investigations in a way that makes it work.
Well,
I don't think
you're
it's
not-
the only gateway. I think Childline is a gateway, but if we get the call at our county agency and it's child abuse, we're going to take the call, we're going to investigate, we'll call Childline.
Right.
So it's one gateway, but the agency is the other gateway. Likewise, we get calls from Childline on GPS referrals. No one's telling people no. They're accepting the information, it's passed down to the county, but it is a back and forth. We do the same thing if we have a report of a child abuse, and then we're going to call it in, and we're going to make sure that it is numbered through our agency, and we're going to go out on it immediately. It's not, we're not going to tell a family member, oh, call Childline. We're not going to do that. We're going to get the information from them, all the particulars, and then we'll call it in. So those families are getting, I believe, once that, I can't make people call. I can do outreach. I can work with professionals in the field. We can provide ongoing training. Everywhere that's asked, we're willing to do that. But once that call comes in, I can guarantee that our county is going to respond to all those calls.
And-
You see how that-
and you're-
you see that-
You're nodding, ma'am, you haven't had a chance to
I
contribute.
know. No, I know. Well, most,
In Blair County as well, and can we assume that that's pretty much,
right. I'm
Children,
listening, and there really isn't anything different.
okay.
And that just
We're doing
points
it.
out the practice, you know,
Right.
that, see, you can't make a system, okay, let's make a system, it'll work perfectly if everybody calls Childline. You know, well, it's not that simple. It's a matter of practice. If you say, call the county agency and someone says, oh, you need to call Childline, we don't care about what you need to call there, we don't handle that. But Rick's got the same situation, but he approaches it differently, so that's what makes the difference.
I'm sorry, Don.
I'll chime in. Because really, I'm almost hearing, okay, well, if it's CPS or it's GPS, you know, we do the same thing and everybody gets treated, but it's not the same thing. Like, it's not the same thing. GPS is a voluntary system that doesn't get tracked. And in my experience, we see disasters after report, after report, after report, that go, maybe there are 2 CPS in the past, but there have been 8 GPS referrals in the past. And so you need a system that is accountable to children, I think. And you know, to say, well, you know, it's not voluntary, GPS is a voluntary system. I think as the law is written.
No, that's misunderstanding. GPS is not voluntary.
No.
It's simply, we go to court on as many GPS, probably more than we do CPS. So it's not separated by GPS being court ordered and GPS being voluntary. The services are how the complaint, was the child abused or was it neglect? Your GPS are your neglect areas. But many more cases come into the systems, and all of our systems, through the GPS, and I guarantee you, more of them are court-ordered services as compared to the
You have a couple of
CPS.
slides that show that.
That shows the.
So is that, I just don't want, I think that's just a misunderstanding, but I think it's very key for everyone to understand that the CPS cases and the GPS, it's just how they come into the system. That's the only distinction. It is a good thing, though, that you
We
are
don't
correct.
track them.
We
We
do
have
not
to-
track
that's-
them, and I agree,
Make a fine.
and everyone here would agree, the GPS needs to be tracked.
When they,
If I could, oh, I'm sorry, ma'am?
When they, go ahead.
I was gonna say, I think when you're saying they're not tracked, what does that mean? What are you saying?
We don't have a computer
don't
record.
even know.
From one county to another,
Oh,
I think each of the counties keep their own record.
Right, that's
of
what I was
it.
gonna say, the
Sure.
But-
counties,
Varies.
yeah, individual counties, so you're talking statewide. But my understanding was that maybe the ability eventually with our new
yes.
state system,
Yes,
that
we're
we
moving
would
in
be
that
able to do
direction.
that.
Can I go back to this calling in? I want to try to narrow it down so we can really get some more concrete things. We've heard testimony about the numbers of dropped calls to Childline. I know, and I know counties do intake, I'm very familiar with multiple counties intake process. Do you have any idea, is there such a thing as dropped call data? In other words, if somebody calls Lycoming County or Blair County or Allegheny County, says, we have a suspected child abuse case, and they're calling in, perhaps it's disconnected for technological reasons, there are too many people on hold, or do you track the numbers of cases that are dropped? Where
We
people
track-
call back and say, I've tried 3 times and I can't get through?
In Blair County, every single call that is called to the agency is recorded. And there is a disposition. Went to voicemail, call was taken. I don't know if we use the word call dropped, but it's every call that comes into the agency is recorded and tracked.
And so it seems to me that counties do a much better job of fielding these calls. And I don't know if Mr. Attorney,
Well,
you're getting at
how
that.
would
Well, you know, they probably does.
Well, I think, okay,
varies.
the 3 we have before,
You don't see calls.
it's not all.
Don't make that assumption.
Yeah,
Okay.
It should 75 counties, whatever the hell it is.
67.
67 counties. Well, we got 3.
It's all
So
different.
let's talk to the other 64.
Should we look at the way calls go to Childline? In other words, should we look at changing that system to say, instead of them being data collectors and doing what I pet peeve in my minimal fact inquiry, should we instead say, hi, this is Childline, where are you calling about? Calling about a case in Harrisburg. Okay, hold on, I'm going to connect you to Dauphin County. And let the people that train in Dauphin County's process and procedures handle it.
Well, part of it, and I'm not sure how every county works, but do they have 24/7 capability?
Right.
You know, we do, because we're a big county. I'm not sure that, you know, that they have 5 people who are taking those calls, doing that kind of thing, and tracking it that way. But I think you can look at passing it to the counties, but you have to have some sort of computer system that tracks across. And I think that's part of that whole thing about not being tracked. I mean, we all do our own individual pieces, and some counties are more advanced than others. You know, I think we here do a pretty good job around this stuff, but it's not universal, and if someone from Lycoming comes to Allegheny County, we never know it, and vice versa.
One more-
Just,
I'm sorry, one
Yeah.
last, and I'll try to get off my soapbox. Do your counties have a process by which you prioritize who's calling? In other words, if a mandated reporter is calling, do you give them some sort of priority in how their information is taken?
We take the calls that comes in. And well, one of the things we do though is any child that's under age 6, no matter what the call, we would have normally screened out that call. We're gonna go out and do a field screen anyway, just to take a look at this kid, to eyeball him and see if there's anything there. Because we feel that young kids are most at risk. And rather than have that screen out process, because a lot of cases normally get screened out.
Can you just clarify what you mean by that? You would screen at somebody under 6?
We don't.
Oh.
But in the past, we used to. But we stopped that maybe 10, 12 years ago. So we go out and eyeball them. It's not a full investigation unless there's something there. So even if it's a real, something that normally would not rise to a level of even going out, we still go out and take a look at these kids. And we've saved some kids that way. And we did it because a child died in 2001, because we screened it out. We had a call, we went out, there was nothing there. We get the same kind of call 2 days later, he said, oh, we were out, there was nothing on this case, and sure enough, this child ends up dying. He said, we're not that big, we can easily just go out and take a good look, and 90% of those, they screen it, we go out, there's nothing there, we close it at that point. 10% of them come into the normal investigative process, and a few of those kids, I think we really have saved, babies especially, because they're most high risk.
And there's new GPS response times just went into effect in July
Right.
across the
And
state.
they kind of adopt a lot of it.
And those new GPS guidelines really do look at, and you look at the vulnerability of the children. So the age is a major factor, and it can be, even though GPS can be an immediate response. So regardless whether it's a CPS, which is minimally a 24-hour response, you can have GPS cases that you need to respond to immediately because the safety factors are there and children may need to be removed because of a GPS case, the same as a CPS. But that just went into effect here July 1st across the state. So there are some regulatory unified systems, and there are minimum standards. Like Allegheny has put together some things that are actually ask for more, and you can in that in your counties, and a lot of us have. At least now there is a minimum requirement for response times for GPS.
Let me, if I may, just exercise the chair's prerogative. We have about 10 more minutes, and then we're going to have to pull the plug. Are there any other materials that you wished to present that we've sort of intercepted? This is, as you can see, a fabulous panel.
I think what I would like to say to the panel is a lot of the conversation, a lot of questions you've asked, thank you, Mary, for sharing with us what might have been some questions. Answers, we did have a conversation about them. Answers are actually listed in the PowerPoint. So the issue about a GPS data tracking system, we addressed that in the PowerPoint. I'm going to skip to, so you see we had some questions about suggestions around modifying the CPSL, suggestions regarding GPS case data. We weren't asked this, but we wanted to share with the task force some of the things that we saw from our perspective as being strengths with the current system. So not everything's broken, and we think there are some strengths. A lot of children, a lot of families do get service through the Child Welfare Agency, through the prevention services in the community, and through the court system. But then we did talk about what are some suggestions we had for improving the system. And that open courts piece really is about what we've been talking about earlier. It's really about transparency of the system. When we talk about how kids can be safer, the more transparent, the more involved the community is. Government does have a role in protecting children, but it's not the sole role. And the community has to be part of that child protection. You've heard a couple of folks talk about family group decision making, and that is a practice that really involves the people who touch the lives of individual children in making sure kids are safe, having eyes on them 24/7. A caseworker won't, a judge won't, but we've got to get the family around and the professionals around that child to be educated about what they're looking for, but also to feel as if they have a voice and to know what's going to happen in the system so they're not afraid to call, or when they do call, they don't think it's just dropped off into a black hole. Judge Henskirk, go ahead.
Well,
Well, I was just going to suggest, Sandy, maybe we each could go down the line and say our one best thing. This is what I would like the task force to think about, is better communication. And adequate communication doesn't necessarily mean the regular kind of brochures or things. We're not getting to the right people. Remember that people are using social media now, and there is absolutely no reason why, in very plain language, we couldn't be putting out there, we government, courts, and CWAF and everyone couldn't be putting out there, it's your responsibility to protect the children in your community. Here's how you can help. Plain language, how to do it. But in order for that to actually work, I was really struck by the article in the paper in the Sandusky thing about the janitors. In order for that to work, people have to believe that this culture of power and privilege is going to be trumped in the courtroom by a balanced and accessible courtroom process or any other kind of process that you put in place. And that balance is going to require that parents have representation. That was a victim. That child was displaying unusual behaviors. That parent is not going to go to their children and youth agency. Why would they do that? They would think maybe the children and youth agency is going to take this kid. They were not the perpetrator. And if that child disclosed to them in the living room that something happened to them at Penn State, and they didn't believe they had an adequate response to the power and privilege that was in Penn State, in the courtroom even, with a representative, a lawyer sitting right next to them saying, my client did not abuse this child, I'm not taking this child from my client, they're going to be frightened to bring it to the court. So I have three main points. Better communication, make it accessible to people, and stop using old media to do it. Brochures are not going to do it for the 18 to 35-year-olds that we want to reach, who may know about this little child or the 8-year-old who went to the program at Boy Scouts and somehow is acting funny right now and they can't quite figure out what it is. You've got to get into the social media and every other place where the people we want to reach are actually going to look for it. So,
Let me, before you go, Mark, I hope that each of you will be willing to help us get very specific about what we should do. Increased prevention services doesn't mean a whole lot to me, unless you tell me what that means. So I want to get past this boilerplate business. We all know that we should increase prevention services, okay, fine. We want to get very specific. I can tell you, I'm sitting next to the judge. Penn State's being talked about in Montreal. I'm in St. Thomas that's being talked about. I'm telling you, there is a level of awareness about this situation that's almost going to compel this task force to come up with something that's really got some teeth in it. And that won't do it. These may be good headlines, but we need details. And so I'm suggesting that we stay in touch with you after your recommendations. Maybe we even employ a professional to actually put some specificity to this stuff so that when we put our name on it, it's got at least the appearance of practicality.
Bill, I have been doing some research on some of the best practices, and I know several other people have looked at that, so that's certainly something I'm going to be saying, that we need to spend a lot of time looking at some of the primary prevention programs that are out, and there's some science behind some of those, so that's my agenda, and I've already had people getting research on some of those promising practices that help do that sort of thing.
But I will say, one of the most striking things that I've heard on that score is brochures won't do it. I have, in other contexts, I've seen an amazing number of brochures in the course of our, and they just don't get out there. There is, now, you don't get me by the internet, but at any rate, in the dwindling time, and I think I'm going to ask Jim Anderson to frame this. One of the discussions that we're definitely going to get into with regard to both is this issue of founded and now, indicated is the bureaucratic determination. Founded is what the court does, except it's not clear to us whether who does, whether some judges do, and in what cases do. Jim, could you frame that a little better?
I could. Thank you. I will. I'll try to.
I'm sure you will.
Of course, you know, and certainly the panel knows, that there's been significant focus on abuse report on the accuracy of the data and how Pennsylvania's numbers compared to other states. But in the course of this, there have been an increasing number of questions about the issue of the founded report and what that means in the various counties. And as you know, that the definition is that there's been a judicial adjudication that the child was a victim of child abuse. And there is a judicial adjudication that in some way, whether it's a criminal proceeding, could be a juvenile proceeding, that that child was a victim of abuse. And the numbers, in the statewide numbers, are very low. I think it was 73 in the year 2011. So if you look at the number of cases that come in that are criminal cases, where there has been a conviction or a plea of nolo contendere, or there's been a juvenile delinquency case that went to court and the child was found dependent, there could be the opportunity for the court to make a specific determination that the child has been abused. And I think what we've heard is that the practice is vary considerably, but it still ends up in the child abuse registry as a founded report when a children and youth caseworker and supervisor basically complete information, send it to the state that in their judgment there has been a judicial adjudication. So it isn't that the judge has made this determination the child's a victim of child abuse. There has been some court process that has been interpreted by the county children and youth agency that there has been an action that constitutes a founded report. And with that comes court order and a copy of what was the basis for that. So there's certainly some substance there. But it appears that there are cases that had some judicial involvement that likely didn't find their way into the system. And I think what would be helpful is, what is your process, both in the child welfare arena, in other words, dependency court, are you being asked to make the specific determinations that the child is a victim of child abuse? I believe the CPCMS model order provides a drop-down box that, yes, this child is a victim of child abuse, you can do that, but there is no, and I think Jason was getting to this, there's no procedural rule that addresses the issue in the dependency case. And there's certainly nothing in the criminal court process. So somehow that information has to get back to the agency. There's, I think, different processes in different counties. But at any rate, there's a significant difference in terms of the repository. And if it's in there as a founded report versus an indicated report on that individual, and the importance of the distinction is an important one. I won't go into all of that here, but I think it would be helpful. What is the process in your respective jurisdictions for submitting the information to the department that a case is a founded report? And I think your numbers are on, I see on page 19 of your PowerPoint. So I don't know, I think that would be helpful, because whether there should be a difference in the process, whether we should be paying attention to what that process is. And the one thing I think you made clear is that you talked about the response to this child abuse allegation. That's what you focused on. The best practice could be completely irrelevant as to whether it was an indicated or substantiated case. The issue is the child safe? Does the family need service? What are the long-term outcomes? Could be completely irrelevant to what those numbers are or the child abuse report. And it just seems to me that we started to have a focus on the data and the accuracy of the data. What you helped all of us understand is the data and how the case comes in isn't as important as our system response to it. But nevertheless, this is important information, because the other states and the data and the focus on the data, it is something that is talked about. And it's certainly in Bev's interaction with the federal level and national foundations and so forth, we pay a lot of attention to that. So with that, guidance, maybe about how do you do it? Is it important? Are we paying too much attention to this?
But I think it's pretty obvious by these numbers that we don't do it, we don't pay attention to it, it's not really relevant to us. You know, so it doesn't really fit into practice in a lot of ways. And I think you're really spending way too much attention on did he do it or not, you know, and all that kind of stuff. No, my personal.
Well, okay.
Can I just put it one more way? You have a scenario, CYS has to investigate 60 days, you indicated. Prosecution oftentimes can take more time than 60 days, if not always. You end up with, but in that indicated case, you develop your service plan, you got some services in place where needed, and you close the case after a fairly short period of time. Good decision, everybody's doing well. And then ultimately, your outstanding prosecutor from Blair County gets a great criminal conviction. Is there a process in place where that scenario where you had the indicated, so you're essentially closed with the case, but later there's a conviction on the same the parallel facts? Is there a nexus to continue the dialogue between prosecutors, law enforcement, and CYS to make sure it's a simple CY-49 form you send in and make it valid, and that bar keeps kids safe? That's what we're talking about. So we don't get Sandusky going out to the high school to work at a different job after he leaves Penn State.
What does Jason, that require the DA's office to have some responsibility to report to the
I'm wondering if any of that's in place now.
I think it would be, in my mind, it would be the role of the DA's office to train your DAs to make sure that that information gets passed to the right place. Yeah, that's
You
right.
want somebody to look, bring it out.
Should be on office.
Yes.
We did a study though, just to get ready for the task force. I asked my staff to go through the back from 2010 and say, you know, 2009, 2010, were there cases that went before the court and there were convictions, but that our agency wasn't notified through the district attorneys? We had 10 more found. So there were those cases, but there is a disconnect, and you mentioned it. The Children Youth Services, we have to have our investigation done in 60 days. Law enforcement does not. So it could be a year later until they arrest somebody. Then we all know that the system of appeals and how things get drawn out through continuances, it may be 3 years from the time we've done an indication until there's a criminal conviction. And there is not a tie-in, there is no requirement for the district attorney to get anything to us, and it's very hard for us because the case usually got transferred to an ongoing worker through placement or an in-home worker, so that assessment worker has now dealt with about 300 more cases from that last case, and they're not monitoring. There is no monitoring.
And Blair County said we did the exact same thing, and we had the same discussion, and it's pretty much how it is.
So as I understand, and I'm trying to figure out how we get there, and we talked, some of the issues we talked about is redundancy in systems and how we go about intakes and referrals and things. Sandy, families now have a FIN number or something like that?
A bid number.
FIN number, family identification. And Mr. Turner, in Allegheny, I know that there's redundancy in systems between yours and family court, so that if you split the case, then if somebody goes back to try to get custody later on, there's a red flag or something. Would it make sense for us to try to get, in the criminal system, there's a, let's subtract the number. Case number, CRIN number, yeah. Does it make sense for us to try to make a recommendation to have some sort of unifying number or something like that, so that when there's an action in a case involving a suspected child abuse, each player in that system gets a flag or something?
If you can have a system that kind of, you know, is interoperable and actually speaks to each other. I mean, that was just started in India. They have you know, an MCI number for everybody to start dealing with state numbers, but then that's been a slow process. And that MCI number is not the same as if you're in the mental health system or you're in something else. So within the Department of Public Welfare, they can't put it together. So going across systems makes it even more difficult to do that kind of piece. We have our own, within Allegheny County, we developed it and do that, but not everybody's done that.
Is that,
But it makes sense.
something you could share with us to kind of give us a look into what Allegheny's doing?
Sure, my staff could certainly show you how that works, you know, so, sure.
Dumb it down for me.
I was just gonna say, I'm also looking at, with the collaboration and the relationships, this, the model, the child advocacy model, would surely help with this type of situation, because you're gonna have all those same players together, doing the same case. You're not gonna have to wait 3 years. You know, I think it's, you know, we're talking about data, I think that's really good, but then also, we have a smaller county. But if you have a CAC model and you have those relationships and everybody's working, that's also another, which may be a little more feasible in this day and age than waiting for a data system.
Well, I think it's fair to say, without our having started counting noses, that CACs, enhancing them, making them available ideally across the board is going to be something that this task force is going to strongly recommend, and that's someplace where money should go. But and frankly, I'm already thinking that we may need to either punt to a subcommittee the computer issues, the how do we track this stuff, what's feasible, is there a roadmap? I can remember the Ridge administration coming in and it's like, hey, we discovered computers back when, and it's Office of Technology, and as far as I know, they did some good stuff, and we did actually get some computers working in state government. I don't know where we are now, but it's almost that kind of a caveat. You know, Bev tells me that there's somewhere off in there, but it sounds to me like a person who wants to do it.
We're there, we're moving it.
Well, okay.
But
So
it's
the
a
money's,
long, the money's there right now, right, Kath? But it's gonna take to change everything, it's long I want it done yesterday, Kathy said, no, it takes about 35 years.
so at any rate, we have to get our,
The IT people, you're right.
we have to
Told her
get
that,
our arms
yes.
around
But
it.
I was just thinking that when we're talking about the silos and the confidentiality and the transparency, I think the issue has been brought up in child welfare, and we understand that. It's all those other systems. It's not just breaking through the child welfare
Right.
system. You've got to break through law enforcement, the courts, mental health. It's, I think what Bev was just saying. That's a big thing.
And the rubric that occurs to me is that this is intelligence information. It is not for the newspapers. It is not a matter of public record. It is for specific people who have a legitimate role in looking at child welfare. And I see people nodding. Nobody's recoiling at that idea.
But we also have heard through testimony that we're losing a lot of our appeals. Now, again, that brings us back,
DPW appeals.
DPW appeals, correct. And that new Commonwealth ruling that came out last week changes the standard or the burden to a higher level for appeals than for an indicated, which.
Let me ask,
I just wanted, does it matter? Does any of this matter? Should we be, I guess my question, since the judges are here, should we be asking, what are the pros and cons to a worker coming in and saying, Judge, we'd like a finding of abuse for this case?
I think you're gonna see that become less significant as we move to mediation models at the front end. Founded and unfounded really is sort of an old animal, under the old system, because you needed that in order to get services or to get the right finding that you could nail the person down and say, this is an adjudication. You were looking for the system to make that adjudication. And now we're trying to move away from that, the adjudication, because I'm seeing our numbers in Blair go down. Founded went from 10 to 5. Does that mean we have less cases? Does that mean that, we had 15 cases and only 5? We don't know. But I'm guessing if you unpack that, the reason it's gone down is because you don't need to make a finding. You're moving toward permanency. You're trying to get things in place for permanency. Permanency has now replaced the issue of is it founded or unfounded. With abuse, and you're really talking about abuse, in the abuse system, we see so few of those. In Blair County, we really, in terms of how many cases come into the system, there is a small number of abuse cases.
The question is why? Why do you hear so few abuse cases?
what
You know, is it because GPS is working better? How do you know that?
It's the law, the way it's
This
written.
data, I don't know.
Should that change? That's where we're getting.
In 2011, I'm on page 9, I don't know, it's slide 17. It says in Blair County, there were 385 CPS investigations, and 0 were accepted for service. Like, what's that?
That's our process, because when we get the referral in, they are closed after that CPC, after that investigation, and then they are reopened in the GPS. They are closed in CPS. It's the way it's tracked.
Everybody's.
So meaning they're-
Yeah, I know, because I was the same thing. It was, they would then be transferred and accepted for service into the GPS system.
It would be like another unfounded.
Yeah.
Right, and then you're not tracking things.
It's the,
But are any of those criminal? Or do any of those
We don't know.
CPS go?
just reading this,
You don't know.
I'm going to be
It's
devil's
unlikely,
advocate.
very unlikely.
I understand exactly what you're saying, and I think that works really well in a GPS model. And I guess Cindy was saying she's worried that GPS doesn't get enough attention. I think I see the opposite, where we try to make them all level, and they're not. A child with 18 fractures is not the same as a child who's been neglected.
Right.
And if that parent doesn't accept that abuse has occurred, they cannot move on. And so in those cases, I think it actually is critical that this is abuse, and then you can move forward. But I think when we try to put them all on level playing field, there is some danger. I think it's impossible that there's not one abuse case in a county in a year, because, right, but it's just that if you put them in GPS, I understand the GPS approach, and I think that's the way to go, but there is something to be said that there are cases that are absolutely abuse.
Yes.
And they
Right,
have to be a little bit
They have to be
different.
identified
And
though.
I think what I see is a merging of the two, but rather than GPS coming up, I see CPS being like, this is not a big deal, we don't need to, we can move on. But I'm not sure that there's evidence that you can move on, particularly with the infants. I'm not talking about the older kids' discipline. I'm talking about the infants and young kids, that you can move on in this model until you say this is abuse. So I guess I get worried about the one that's all, but maybe for a different reason.
Yeah.
I want to be clear, because I know the folks in Blair, I know that they do a good job, so they do a good job. And while there were 385 CPS intakes and investigations, if you turn to page 10, slide 19, it does tell you that, in fact, they indicated to make sure we compare apples to apples, in 2011, 40 times. So
Right,
it's
it's not-
pretty consistent, if that not
makes
more,
sense.
it's 10% for indicated.
That makes sense.
And they did found 5 of them, meaning that there was a criminal case, a dependency case, or even a PFA on parallel facts where they did stay in the game and provide that slip. So I think we're not saying
It's
lawyers
the
not doing it.
Those
No,
times need to go together.
It's the
Yeah.
system, because even in our new IT system, they get opened up in the CPS, that's the way we do it. Then they do that investigation, and then it's closed. And then it's opened again in GPS.
Whether it's indicated or not
Right.
indicated, it gets
It's,
closed.
right, it gets closed after the 60 days.
Net,
I
net.
know it does not,
Which I
that's
guess
the way you read
speaks to, when
data.
you see data, you
That's
really
right.
have to ask, what does the data mean? Because,
Because they all look the same.
Well, then perhaps at some point uniformity, whether mandated or, if there's funding, it's easy to mandate. At any rate,
Chairman
and-
Beckler,
yes.
I know that we're really
No,
short,
hey.
but we started with the judge in the end giving the 3 top things that she would like to see, and I think it would be beneficial to go back to that. And if we've covered it already with someone, then feel free to say that, my comments have already been covered, but I do think as a summary of their testimony would be helpful to us to get the benefit of collective knowledge and information from their experience. Could we do that?
By all means.
Just going down the line, one thing that wasn't talked about was transparency, increasing the transparency so we don't have this big, confidentiality we hide behind. Open the courts. We've had open courts since Judge Bear was there. And I think we're the only county that has open courts, and I think it works well. If a reporter wants to show up, they can, or anybody else, and the judge could ultimately say no if there's something they felt is not right. But every other court's open, and why not? Why do we have to trade secrets? Because then you don't really get that community time. You think you're hiding. You don't get responses in terms of when somebody makes the allegation, as you said, you know, I don't know whatever happened here. You know, it's, we should be able to share and we should be able to defend what we do. And I think that's a much healthier system.
The two things I would bring out is in our county, we've been big believers in early intervention. So we have caseworkers in every school district because most of the kids, they're in school. That's very commonplace. It's a good way to reach out. They're not known as children youth caseworkers. They're an outreach worker. They don't have a children youth badge. They have a school district identification. And so they work great with the teachers because, especially elementary school teachers can pick up the slightest little thing on a child very, very quickly. And then our outreach workers work with that. We also try to deal with the truancy in that way. We don't call it truancy, we just school attendance issues. But it's very important, it's very hard to reach out to a 16-year-old who's in 9th grade at high school to say the value of education. They go, yeah, I'm not waiting until I'm 22. But it's very good because elementary children want to go to school. It's fun, they have friends there. And so that's the place of input and or to really impact on the families too. But there's other issues going on in the home. And we can go out and we can start working with those families at that stage. So in our county, it's really trying to deal with very early stages. And so our numbers were really, it's misleading when you say, well, gee, they had this many cases referred. We saw a 17% reduction in referrals when we started the outreach in all the school districts because we got it that way and we didn't report it. Because we don't want to waste time reporting it. It's not a full assessment. We're working with the family and we get services in immediately. The next day we can have services for those families. So, as they said about data, you need to ask a little bit more. We said, when we used our data on cases accepted for services and on assessments, where do we do a full assessment where here was an actual complaint? Here we may see something where the child was, when I talked truancy in the elementary, we were acting on 3 days illegal. We weren't waiting, habitual truancy is 6, we were going out at 3. So it really wasn't a reach the level of dependency. We didn't want it to get there. That was our whole goal. Don't get to that point. Engage the family, work with the family. And I do believe that that's an area for this task force to look at. The earlier you're in the home, the more services you can provide, it's more eyes looking at the child to see if there's something wrong. And I think that's a very good stage. The last thing I would say is that there has been, I believe in most counties, a more engaging of the community members in building trust, not just because of the Sandusky case. But one of the things that hasn't been mentioned is the multidisciplinary teams that meet on child abuse cases. We have pediatricians. There is no CNY person who has any decision-making in our MDT. Our MDT, the co-chairs are the guardian ad litem and the county coroner, but we have pediatricians. We have wise options for women there. We have different groups because we want their critical eyes looking at if there is any cases of abuse or re-abuse, what does the system have to look at to try to prevent that in the future? And that gives them that look at the system. It lets our hospitals, our doctors be able to look at the system and give input so there's a better trust, so we don't have a problem with a doctor feeling, gee, should I call it or not? They call in as soon as they think about it. If you have to think about it, you should call. We'll decide and we'll look at those cases. So I think there has been an increase in trust, and we need to improve on that. We could have more people involved and things like that so that you have that understanding of the system. Because I think a lot of the mistrust is not, it's just they don't know the system, and the more we can get involved in, we'll have a better understanding there from everyone.
Unlike Judge Capriva, who talks about being a reform judge, this is only my 3rd year on the bench, so I've come into this system with everything that's been developed through the roundtable and didn't know the old way. The weakest link I see in our system, though, is our parent attorney. In my 2.5 years, I've had 5 different parent attorneys. So those families who have been in the system, every time they walk in the courtroom, they could possibly be having a different person representing them. And so if there's one thing that I really think would be important is to get that funding in place to help so that I can convince my commissioners to pay a little bit more and get a contract position, and have someone who's passionate, because in our system, we are all very passionate about this. We have very good cooperation together. We attend the roundtables, we go to the summit, but every year I go, I have a different parent attorney with me, who doesn't have time to even get involved in the process, because they're, it just doesn't hold their interest, because I can't fund them in the way that I fund my GAL or the solicitor is funded. So I think that that's very important. And then the other is the way we receive our funding, which I know was touched on, which is we've done a very good job in our county with all of our services up front. You just heard Rick talk about how we've gotten involvement in the schools, so we've even avoided referrals going down. Well, that only punishes us in the end, because we don't have the numbers to support. And I think that there should be almost a reward for being able to do this, that we can continue. Our fear is, all it takes is one family with a bunch of children that now come into the system that can completely skew our numbers and mess up our funding. So that's another area I think should be looked at.
Jason,
Yes.
look at your voice.
Bernard's anxious to hear the question on that.
He's afraid.
I would just echo what everyone else has said and just highlight the Child Advocacy Center. I mean, I think we heard it here. How did Allegheny County get to where they are? Because of trust. And if you really want to make an impact, really funding and recommending the CACs, I think is going to have your biggest bang for the effort that you put in, because it's going to bring people together. It's going to put the data on the table, people being able to share it, and that leads me to the second one, which is the real importance of data, whether you see it on the criminal justice side, the mental health side. Everything's about data today. Data. You can't do anything with limited funds without the data supporting it. And so that would be a really big one. And I just loved your comments about prevention, because we spend so much time and effort thinking, how do we make a system catch this after it's happened, without thinking, wow, if we would have spent that much time and effort on how to prevent it, then we wouldn't even have to have this problem. And so I don't think you can highlight enough that your report would focus on prevention, community involvement. And, if the task force was generated out of Sandusky's incident, I mean, you're talking about culture, power, and sex. I mean, that's a really, really big community issue. And to just ask the task force to make a system that addresses that is just ridiculous. So, don't beat yourselves up over it, is what I want to say, because, you have Luzerne County, you have the Catholic Church, you have Sandusky. I mean, you're going to have those examples of power and abuse, and if you try to make systems to correct that, you're not going to be able to unless you change humankind from good and evil.
But we've
So-
got to make a check, we've
But
got to try.
you
You got, and I think we have ideas here generated that are important, but just keep that perspective is what I'm saying. Just keep that perspective that, you're not going to, what's annoying as a judge is, you have an incident and then the legislature writes a law and says, okay, we're going to take care of this, and it's all done in a vacuum without really forethought to the whole perspective. And, they name it after a child or something, I mean, it's just important, but that, I don't think that's responsible legislation in many instances. Some maybe, but, the general thumb is to really try to go at it in a measured, reasonable fashion, and I think that the data, the CAC, the prevention, all those things will help in that process and be very powerful in your work. Thanks.
At the end. Yeah. I echo everything that everybody said, but I also would like to highlight that to really maintain how we work with families, the relationship and the strength-based, and look at models for that instead of the adversarial, because that's how it's been for years and years, and where are we? That's one thing, and the other thing would be looking at the services that are funded, or when you're really recommending things to, it's a profession. This is a professional, and to really make sure it's research-based and outcome-focused, and we just don't start, other professions do that, and we don't just start putting things there, and we don't have the evidence behind it. But other than that, it's pretty much what everybody else does.
It's civil service.
And so, well, I know we've been looking at that for a while. That is a hindrance to hiring. We've been looking at that for now.
It's also a hindrance for getting rid of people that don't do their job.
Well, I always say when you're looking at the child welfare system, depending where you are, when you look at the layers, there is the county, the salary, how do you have to hire? Then there's the unions, many agencies have unions, and then we have civil service. So it is quite and I think Judge Kariba did say, we can find that we can attract social workers, that we're not attracting somebody who just wants a paycheck. We need to be able to attract social workers and people in that field.
We heard from the University of Penn professor, the art history major, for the past 2 years in the field. Ms. Moore, any final?
I just want to acknowledge how important this issue is. Obviously, everybody in this room knows how important it is, and everybody probably who's going to watch whatever they're taping knows how important it is. But I really think the relationship between the court and the agency and the community, and quite honestly, not one system's going to fix this, all of the systems working together. So I appreciate that the task force invited us to come and talk, and we're so gracious with the amount of time that you gave us to talk, and I really appreciate the judges and administrators who took out of their time to come and speak with you. So thank you very much.
Thank you. We were supposed to start lunch, I think, 25 minutes ago.
Better we usually do.
What's her time?
You get a few of our kids there. Nice seeing you. Yes, we do.
Where you going?